Everything you ever wanted to know about lawyers? Maybe not everything, but you were afraid to ask. Hi, it's Ron. I said in an earlier episode of this series, the Everything You Ever Wanted to Know About Being a Lawyer series, that I was not going to talk quite so much about the procedural stuff because I found that it was just impossible to organize the information the way that thought that it really ought to be done. But I would do a sort of more of occasional answers to questions as they may come up, or things that I thought would be of interest to viewers. One of those things seems to always be war stories, and we try to into those a little bit more. Part of what I need to do before I would get too much into war stories, though, is to have a basis for understanding the context that they come up in with the explanations of how things work. Now, it happens that that a little bit after I uploaded episode number 3, and I'm looking now at YouTube on March 2nd, 2021. We got a couple of questions from a viewer.
Missing the mark.
You hear him? From Missing the Mark.
We represent people who are.
They've got commercials on my feed now, so you'll have to excuse me. So Mark asked me a couple of questions about my introduction to discovery. One of them was, it would be important to hear about the relationship between the law firm and its client during discovery. Does the law firm act at all like an outside auditor, or do they rely entirely on the client for all production of documents? That's a great question, Mark. Compliance with discovery is the lawyer's responsibility. At the end of the day, if there's a problem, the lawyer is much more likely to get in trouble unless the client affirmatively misleads the lawyer about what's in its files than the client is, because it's the lawyer's job to make sure that the client understands as soon as litigation is contemplated, or once the person has been served in a lawsuit or even threatened with a lawsuit, that they cannot delete things, they cannot destroy things, what they have to preserve, what they have to maintain. So the answer to that question is, you get varying levels of cooperation, varying levels of involvement. Some major companies, large companies, have their own in-house document production and discovery compliance teams, which are very helpful to an outside lawyer. They save a lot of money for the client, and they reduce fees for the outside lawyer, usually considerably. But it is very good to know that the client is handling that. And if the client has an in-house attorney that is supervising that team, that's really good also, because that takes a great deal of the responsibility off outside counsel. But other than large companies, which tend to be publicly held companies that have those kinds of resources, if you represent mid-market and smaller clients such as I do, you're going to have that responsibility yourself. And ideally, you have a junior attorney or an experienced junior attorney or a mid-level attorney working with a paralegal or a vendor who specializes in e-discovery, or which is essentially all discovery these days. Getting familiar with what the client's data looks like. Is everything on Outlook? What are they using for emails? What are they using for, are they using the cloud? Getting their arms around what has to be produced, what has to be reviewed, what has to be logged as confidential or privileged, and it's a partnership. So the answer to the question, Mark, is the law firm does act sort of like an outside auditor. Ultimately, we can't be better than the client, but if we have reason to believe that the client is not being forthcoming, the duty is on us to challenge the client, and if necessary, to go into the sort of stickier areas of ethics that I think we don't necessarily want to go to now, but where you might have to either withdraw from representation because you know that your client is withholding potentially relevant information, and then perhaps deal with getting another outside opinion on the matter of whether or not you have to inform the court about this. So that's an answer to Mark's first question, which was asked 2 months ago. How do you determine what to demand in discovery? It's actually a rather detailed series of questions that he asked, and it's a shame that I waited so long to answer him back. But how do you determine what to demand in discovery? What you want is information that the other side intends to rely on to prove its claims or to prove its defenses, as well as all other information that you're entitled to, in other words, which is responsive and not privileged, that would help you prove your claims or your defenses. That's the simple answer. So what you do is go through the pleadings, look at what the elements of each cause of action are, and there are more or less standard categories of information, depending on the area of practice that you're involved in, that help you determine what kind of information would be needed. You also want to know the names of every person on each side who could know relevant information or who could be called at trial to testify. That's really, really important. Next question he asks, is it an iterative process where finding things leads to more demands, etc.? Answer, yes. We say, for example, with respect to interrogatories, that, in fact, in the Southern District of New York, there, just to use an example where they've actually institutionalized this concept, you're not allowed to serve what are called contention interrogatories, which means interrogatories that basically go to the parties' legal positions on certain areas in the case. It's rather entirely of the who, what, when, and where category. And the idea is if you are diligent in discovery, that you serve an initial set of interrogatories and document demands, get the basic who, what, when, and where information, and then you send us a second set 6 weeks or 8 weeks later, following up based on what you've learned. The same thing with, in a somewhat different way, with depositions. Depositions are often categorized into discovery depositions or what we might call strategic depositions. Discovery depositions are, again, questions about the who, what, why, and where. You can only depose a witness once under normal circumstances, so you have to decide who's going to be appropriate for the who, what, when, and where questions. Who's in charge of this? Who would have made that decision? Where are those files kept? And then when you get the transcript, you sit down and you say, who else do we need to talk to? And those would be the more strategic depositions where you're trying to pin down the stories of the relevant witnesses, not to ideally to do gotchas during the deposition process. Sometimes there's a place for that, but frequently it's a mistake that lawyers make. What you want to do is save those gotchas for trial. Next question that Mark asks, I'd be curious to know whether this can be abused for lawfare and what defenses there are against it being used as lawfare. It is, in fact, abused for lawfare, and the best defense to abuse it is to get the case dismissed. Is it possible to get a protective order to avoid harassment, improper use of material that is obtained during discovery? It is possible. It is often difficult, and it often depends on the sensibility of the judge and how much he or she is impressed by that risk. Everything that is produced in discovery is presumptively available to be released to the public. When, if ever, do such documents become part of the public record? Well, it certainly is. It would be very unseemly. Hold that thought. You're thinking, Ron, why would that ever matter? It's a dog-eat-dog world out there. I'll tell you why. Regardless of whether the information was embarrassing or private or whatever other problematic issues there might be, I would almost certainly complain to the judge and say, Judge, this seems to be something other than a litigation. It seems to be that lawfare or some kind of public relations mission is afoot here. And chances are you're going to get the judge very annoyed. That's why unseemly matters. If it looks like it's something sleazy going on, you're going to the side doing it is going to get in trouble. When documents often become a matter of public record is when there are motions filed based on those documents. The courts do not want you filing routine discovery materials. They don't want to clog up the case docket. People dumpster diving in the electronic filing. On the other hand, there's a time when documents are going to be used. Now, sometimes those documents, they're confidential and the court is sufficiently convinced of the need and the appropriateness of it under the governing legal standards, may agree to retain some of those documents under seal. Some judges are very reluctant to use seal. There's a general policy that anything that's done in the courts is and should be a matter of public record. But other judges are a little bit more protective of private parties, especially when both sides agree to some kind of confidentiality, and will go along with it. It really depends often on the judge, and unfortunately, appeals courts tend to be very reluctant to review the decisions by judges in these matters, even though there actually are constitutional concerns with maintaining materials under seal, which have been enunciated by the United States Supreme Court. Okay, going back to Mark's questions, another interesting topic would be what it's like sifting through all the documents one gets back. I seem to recall hearing that it's a tactic to try to bury the documents that the requester wants in a flood of ostensibly related but unimportant documents that will make finding the important document like looking for a straw-colored needle in a haystack. Is that real? So, to a large extent, that was a useful tactic back in the days of when I started out, and those were those days. Manual inspection by junior attorneys of physical printouts, photocopies, and you could do a document dump and try to hide things, although your job as an attorney, overpaid for the actual task involved, in theory, was to justify that overpayment by finding that hot document that has been hidden. Such a tactic, I'm not so sure that it works all that well, all that often, but it's out there. It's less relevant now with the extensive use of scanning and character recognition. All sorts of automated processes, included artificial intelligence. I think it's less of an issue than it was 30 years ago. Mark's last question, another interesting subject would be document retention policies. This is, Mark, you really could be giving an introduction to document review, at least circa 1980s. Why do more companies have a policy of destroying all documents after 90 days? Well, 90 days would probably be problematic for many, many companies because of regulatory requirements. They have to keep a lot of documents in regulated industries, for example, in the chemical industry, in medical, all sorts of industries. There are requirements for record retention. There are also requirements for record destruction. Those are often ignored. Both internal policies and government requirements or regulatory requirements for records retention are very, very frequently ignored. Why? Because people are afraid, ultimately, to destroy documents. Keep in mind that when you destroy documents, you're not only destroying potential smoking guns and incriminating documents, you're also destroying potential exculpatory documents, documents that show just how carefully you did design the airframe or the software. So in a well-run company, there's a disinclination to destroy documents because you want to make a record of how good your processes are. And in a poorly run company, there's a disinclination to destroy documents because they don't really keep track of things in any sort of organized basis. And they want to always be able to go back and find out stuff, usually for business purposes. Well-run companies do have very precise and well-organized document retention policies that are executed properly, but those are probably the minority of companies. Don't pay attention to document retention or even management and security until they get involved in litigation, and then they have a very rude awakening. So those are my answers to missing the marks questions. Excellent questions. All the right questions, in fact, to my early March introduction to discovery. And I hope that he and others who find any of this stuff interesting found my answers to his questions today interesting. And I thank you again for tuning in. And if you have any other questions, feel free to put them in the comments here, and we'll talk again soon.